Good afternoon, everyone. I think the majority of participants have now joined. Good afternoon and welcome to Doughty Street Chambers and this webinar that's being hosted by our immigration team. My name is Antonia Benfield. I'm a barrister here at Doughty Street and I'm chairing the event this afternoon. We're delighted to be joined this afternoon by eminent scholars and lawyers in the field of refugee law for this event to celebrate the 70th anniversary of the Refugee Convention. We, of course, use the word celebrate with trepidation, given the current threats that are posed to the convention in the UK. The Nationality and Borders Bill currently before Parliament presents the greatest threat to the UK's asylum system in decades. This afternoon, we'll be drawing on the academic and legal expertise of our speakers to consider the impact of restrictive offshore policies and other externalization measures and how they undermine the convention, as well as considering strategies that can be employed to ensure the endurance and development of the convention in the years to come. If I could just address a few points of housekeeping before we get started. You will have noticed that your video and microphone have been automatically muted, and that's to ensure that the event runs smoothly and there's no interruptions. The webinar is being recorded and will be made available on our website shortly after the event. There's also a live auto transcription function enabled for this event, which you can probably see at the bottom of your screen. If you wish to disable that function, you're able to do so just by clicking on the live transcript button at the bottom of your functions at the bottom of the page of Zoom and just disable from there. We're going to start today's event with an in-conversation between Professor James Hathaway and Laura Dubinsky. We will then move on to our panel discussion where you'll hear from three excellent panelists speaking from both international and domestic perspectives. We're very grateful to all participants who've provided questions to Professor Hathaway in advance of today's event. In the course of the panel discussion later this afternoon, we'll very much welcome your questions to the panel and have time reserved at the end of the afternoon to answer as many as possible. Professor Hathaway is, however, unable to stay with us for further questions from the floor. So please be aware that as much as you're all very welcome to use the chat function, which is visible to all attendees, we'll be unable to address any further questions in the course of Professor Hathaway's session. I'd like to now pass over to Laura Dubinsky, who is a barrister at Doughty Street Chambers and a specialist in public law, immigration and civil liberties, with particular expertise in asylum claims. Laura has acted in significant claims in the senior courts concerning the interpretation of the Refugee Convention. She also acts in many claims challenging government policy and practice relating to the asylum system, for example, concerning entitlements to accommodation, access to legal advice, and exercise of detention powers. Laura, thank you. Over to you.
Well, it's a very great privilege for Doughty Street to welcome Professor James Hathaway, and we only wish that circumstances allowed us to welcome you, James, in person today. James is the James and Sarah E. Deegan Professor of Law at the University of Michigan. He's the founding director of Michigan Law's program in refugee and asylum law, as well as a distinguished visiting professor of international refugee law at the University of Amsterdam. And James is rightly widely seen as one of the world's foremost refugee law academics. His powerful, erudite exposition and encyclopedic research are often cited by the highest courts in the common law world when construing the protections of the Refugee Convention. So when the UK Supreme Court recently considered an SG Eritrea the meaning of lawful presence, it was Professor Hathaway's work that the Supreme Court evidently considered it had to surmount to reach its controversial conclusions. As Antonia indicated, we asked those of you booking in to send your questions, for which many thanks. I'm going to put some of those now to Professor Hathaway, with apologies that there won't be time to ask all of your excellent questions. James, the UK government, as Antonia already indicated, is seeking to enact legislation which is really a multi-pronged attack on on our compliance with the Refugee Convention. But one facet that I want to ask you about is that it will effectively require asylum seekers to claim asylum in the first safe country of arrival. What are your thoughts about that requirement? Does it have a basis in the Refugee Convention? And also, is it logical as a matter of policy?
No and no. So this is one of Europe's, quote, gifts, unquote, to the world, the idea of a duty to claim protection in the first safe country of arrival. There's nothing in the Refugee Convention about it. At most, Article 31 has the possibility that an individual who spends significant time in an intermediate country where they don't claim asylum might be penalized if they chose to move on, but they certainly can't be denied protection, much less sent back to the place they came from. So this is a regional add-on from European Union law codified in the Dublin regime that has tragically been purchased, if you will, by Canada and the United States and others, but has no currency whatever in the Refugee Convention. And as to the second part of your question, which is really the important part, it's quite frankly a really dumb idea. It's a dumb idea because what it does is effectively force, if it were to be the norm, would force most refugees to seek protection in a state very close to that which they've fled, which exacerbates the dramatic burdens that states in countries in regions of origin already face. We now have a situation where the whole developed world only protects 15% of the world's refugees. 85% of the world's refugees are being protected in countries that in many cases are unable to meet their own basic needs. All that we do with first country of arrival is exacerbate that tendency. And of course, within Europe, you've seen that where states like Italy, Greece, Spain, and others have assumed responsibilities, whereas northern countries have assumed relatively few. So it's just, it's not legally grounded in the Refugee Convention, and it makes burden and responsibility sharing virtually impossible.
Going back to the first part of that question, to what extent did the framers of the Refugee Convention envisage that asylum applicants would have an element of choice as to where to seek refuge?
Well, they absolutely did. And indeed, even well into the 1970s, Executive Committee Conclusion 15 is still good law, suggests that the refugee has the presumptive right to decide not where to get protection. I mean, where you get protection is ultimately to be decided by states, but where to seek protection is something that, to the extent the refugee himself or herself is able to get to the state party that they prefer, that is very much intended to be the choice of the refugee. And if you think about it, again, there's a logic to this. There is no international rule about what an asylum system needs to look like. Each state gets to make up its own procedural norms. It's logical then to let the refugee choose where to take a kick at the can, if you will. If states have the right to decide how to run their system, refugees should have the right to decide where to solicit protection, so long as the state party concerned is indeed a party to the refugee treaty and taken on the obligations. So this was a million miles from any contemplation at the time the convention was drafted. As I say, it's an add-on that occurred in Europe during the 1980s, and it has a very pernicious pedigree that is, you know, it always shocks me when I hear students say, well, what about the first country of arrival rule? And I'll say, so where's this rule come from? Open your Refugee Convention. Tell me where that is. And they sit there searching madly, particularly European students, quite frankly, because it's become such an article of faith that they assume it has to be in there, and it's just not.
Thank you very much for that. On another element that's very much in the forefront of the minds of your UK audience, looking at the government's proposals in the Borders Bill, What are your views on the lawfulness or the compatibility with the Refugee Convention of penalizing refugees who reach the UK through irregular routes? And that could be penalties through criminal law, or by granting them a disadvantaged form of status, shorter leave to remain, lesser access to public funds, diminished or non-existent rights of family reunions, by contrast with refugees who reach the UK through formal resettlement routes.
Right. So first, let's take one step back again on this, right? You premise the question with people who arrive by irregular means. And where does that idea come from, right? I mean, at the risk of being slightly off color, it sounds like something that's out of a laxative commercial. There is no regular route for a refugee to arrive. She or he is entitled to arrive however they are able. So there is not a distinction between regular and irregular entry. And I think as lawyers, we need to be very careful about not buying into that language, because it presumes that there is a proper way and an improper way, which is just not true. If you are a refugee, you are legally entitled to get out in whatever way you can, and to get to an asylum state in whatever way you can. And by the way, that includes smugglers and traffickers. This part is not a European disease. This is the Australian disease. The idea that somehow people who use smugglers and traffickers are illegitimate. I mean, the reality is, with borders conceived and controlled and managed the way that they are, it is increasingly the case that those who don't have a smuggler, or indeed, tragically, in some cases, even a trafficker, to get them to where they need to go, simply can't get there. They can't avail themselves of the rights that the Refugee Convention in principle bestows upon them. And so all of this was known to the drafters. In fact, that's why when Australia at one point during the drafting history said, well, you know, people have to arrive properly, right? And the rest of the drafters sort of looked at Australia in one of those, like, what language are you speaking moments? And said, well, of course not. And indeed, they then added Article 31, which provides that refugees may not be penalized for unlawful entry, because there is no such thing as an unlawful entry if you're in flight from the risk of being persecuted. So rather than requiring states to eliminate their immigration barriers, which serve more general purposes, what the drafters of the Refugee Convention did, I think quite sensibly, is say, that would be too big an ask. We're not going to say that your immigration walls have to come down so that refugees can get in, but you may not apply those immigration walls to people in search of protection. And if you do, you breach Article 31. So Article 31 is, I think, an incredibly important bulwark against the kind of retrogression that you're describing, Laura.
Thank you for that memorable response. I think quite a few of us will probably spend the years to come arguing these points. And I hope that we can use some of your phrases, including that the terminology is reminiscent of a laxative commercial. You mentioned smugglers and traffickers. The UK, of course, argues that its plans to penalize refugees for arrival by irregular routes will protect people from using dangerous methods or from resort to ruthless people smugglers to make it to the UK. What do you say to that?
Well, I think that that's incredibly patronizing, and it's factually wrong. So if bombs are falling on your home, if the military is out to get you, you would, as I would, I'm sure, Laura, take whatever means you had available to you, including a smuggler, to get to safety, right? There is no country in the world, and that we've all tried this, and protected entry is a great thing to the extent that we can get people out of dangerous places and to safety, that's wonderful. To the extent that we can get them out of third countries and to a more secure place for durable asylum, that's wonderful. But in most cases, refugees are the ones who have to make these decisions. There is simply not a mechanism that is sufficiently global in scope and pervasive in its presence that ensures that every single refugee who needs to move is somehow going to be, jet lifted out to the land of milk and honey where they'll be protected. That is just silly. That is not going to happen. So to the extent that we can enable some people to seek protection, bravo. But the whole point of Article 31 was a recognition that seeking asylum is often messy. It's not clean and neat and pretty. It's not organized and managed and simple. It is inherently complicated. And so the whole idea that we are saving people from smugglers is a little bit like saying to somebody that, they should simply stay where they are and accept the persecution that they're going to face rather than, take a risk on the Mediterranean or wherever. I mean, if it were up to me, if there's a near certitude of indentured servitude in Eritrea or bombs falling on my house in Syria or the Taliban getting me in Afghanistan, and I've got a 50-50 shot with a smuggler of surviving the Mediterranean, you bet your life that I will be with the smuggler. And I think anyone who could actually pause for a moment and think about the realities of the situation and the desperation that refugees face would understand that suggesting that it is somehow saving refugees by precluding them from using what is often the only means to get to safety is a ridiculous proposition.
Another question that was sent by one of the participants was, how can refugee protection systems, both domestically and internationally, be developed to protect people from having to make dangerous journeys?
Sure. And so again, I mean, we have had some good experiences with protected entry regimes, particularly out of difficult first countries of arrival and into more secure regions or states. We should absolutely be expanding those. To the extent that we can enable people to move without having to use smugglers or traffickers, of course we should do that. But confusing that with stigmatizing those who are not able to avail themselves of mechanisms like that is the problem that I'm talking about. It just doesn't make sense to say, yes, we should do more to help people avoid the risks of dangerous journeys. Of course that's true. But simultaneously to say, oh, and by the way, if those efforts don't reach you and you decide to take your life in your own hands to seek protection, we're going to make your life even more miserable by penalizing for having done so, is the part that I think has absolutely no ethicality to it, much less a legal basis.
Another of our participants has asked you to address another of the UK government's arguments in support of a Nationality and Borders bill. So the UK government has suggested that the current system of refugee protection unfairly privileges single fit men and potentially not those who need protection most. What do you say to that, Jen?
Well, again, I mean, the assumption that single men don't need protection is highly questionable, but let's take the first part of it. I mean, I've argued that it is true that the current regime certainly has, at least empirically, been of greater benefit to those who are young, male, and mobile. No question about that. Disabled people, women with young children, etc., have been less able to make the move that's required in order to seek the protection that asylum, at least in principle, offers. So that's clearly correct, right? I don't disagree with that. But part of the answer to that is to recognize that to the extent the less advantaged groups are able to move at all, it typically is within their region of origin, right? You may be able to get across a land border, if not all the way to the UK. And what do we do there? We do absolutely nothing other than offer little bits and bobs of charity. There is no binding duty to meet the financial burdens of those states or of the refugees themselves. We do not assume any responsibility in law, even to resettle out after a period of years, those who can't safely go home or become locally integrated. So if you're really worried about these groups, if you're worried about the groups that aren't able to avail themselves of classic asylum seeking behavior, then what we ought to be doing is working much harder, not only on protected entry routes, but on relieving the responsibilities of countries that are close to land borders that receive more of those disadvantaged groups and which could really benefit from them. Not the crazy global compact sort of blah, blah, blah stuff, but a real binding commitment to responsibility sharing. I mean, I've argued for a long time that resettlement should be seen as part of the protection process, not as an add-on. It doesn't make any sense that we are now resettling less than 1/3 of 1% of protracted refugees in a given year, right? This is an incredible hardship for the refugees and for the host countries that are receiving, again, as I said, 85% of them in the less developed world. So if we want to have this conversation about equity on grounds of gender, class, et cetera, let's have it. But that is not an excuse for penalizing those who are able to get to us. It's an excuse, but it's a reason rather to do more for those who are trapped in difficult situations elsewhere.
And presumably, if the concern is safe, regular routes, and also to ensure that women and children are not left behind in desperate situations, that's an argument for increasing refugee family reunion, not reducing it.
Absolutely. And indeed, even beyond family reunion, because I mean, reunion again, you know, not meaning to be harsh about this, but it does privilege at least those who have an anchor in a state far away. What I'm talking about is really now beginning to see resettlement as part of the protection journey, that it makes no sense for us to simply dump that responsibility on the world's poorest countries without any sense of responsibility to do anything for it. I mean, everybody is all happy this week that the United States is coming back to maybe resettling about 125,000 refugees a year. There are more than 13 million refugees in protracted refugee situations. That means they've been waiting on average 20 years for a solution with none in sight. 125,000 is a drop in the bucket. And the United States number at 125,000 would be by far the biggest of any country in the world. So what I'm suggesting, Laura, is that I share the government's view that equity and access to protection is something we should be worried about. I do think the current system is not as inclusive as it ought to be. But the answer to that is to ensure through the mechanism of resettlement in an aggressive way that not that we stop those who are able to get to us from coming if they need protection, but that we reach out to more of those who are less able to get to us through resettlement.
I'm sorry, I think I've lost video connection, but I'm hoping you can still hear me. Can you hear me, James?
I can.
Oh, good, good. So pleasures of internet. The UK government is, of course, arguing at the moment that it is shifting the balance towards resettlement and away from the use of irregular routes, but while at the same time maintaining a very low offer on resettlement. Is there a risk that governments of rich nations will pay lip service to ideas of resettlement, to close current ad hoc routes, but replace them with such minor resettlement programs that the overall result is a major diminution in protection?
Yes, I think there is that risk. And to be frank, the responsibility for that dilemma falls largely at the feet of the Global Compact on Refugees. I mean, rather than come up with what was truly required, which was a protection system for the world that would ensure binding responsibility sharing and burden sharing, that would actually link all of the countries in the world together in a new optional protocol that would operationalize the Refugee Convention in a more fair-minded way, the UNHCR led the charge for what is, quite frankly, the thinnest of thin reforms, where nothing is a matter of obligation, everything is process, everything is verbiage. And so, Laura, when you ask the question, is there a risk that the UK is going to gravitate to that verbiage and say that it's doing things that align with the Global Compact and use that as a pretext for diminishing its true protection responsibilities under the convention? The answer is absolutely yes. But quite frankly, and this is the tragic part, the UK and other states were largely invited to begin thinking about creative mixing and matching of initiatives. There's even this whole crazy notion that UNHCR invented of, quote, complementary pathways. Like, so put refugees in as students or laborers or something else rather than actually acknowledging them as protection seekers just to get to yes. The agency has opened the Pandora's box with the Global Compact to states making exactly the kind of comparison that you are making right now. We don't need, they might say, to focus as much on classic asylum because we're going to be doing more on resettlement. Well, quite frankly, if they were doing the amount of resettlement that they ought logically to do in terms of resources and resettlement and actual capacity, it would be many, many, many times the number that the UK is now talking about, and that is not even remotely under discussion.
Could I turn now to another topic which is particularly painful right now for a UK legal audience, which is pushbacks. Is the prohibition of refoulement being honoured only in the breach now?
Well, that's hard. I mean, so I think it is still the case that the prohibition of refoulement, and by the way, when I speak about that, I'm not talking about the silly idea that there's a customary duty of non-refoulement. There isn't one. There has never been consistent state practice on that. But the binding duty of non-refoulement that's in the Refugee Convention, as well as that which is in the European Convention and the Torture Convention, the Civil and Political Covenant, etc. Those duties, I think, do still hold some sway. I mean, for example, we saw right now that the European Court of Human Rights, I believe it was just yesterday, placed interim orders against Greece, attempting to engage in behavior of exactly that kind. So is it irrelevant? No. But I think, and some of the work that I'm sure Daniel will be talking about later on the panel that he's been doing, what we've come up with is a system of basically systematizing non-entree and non-entry regimes generally in ways that, in my view, are very much at odds with the duty that's set by Article 33 of the Refugee Convention. The problem that we have is we haven't got, apart from the small interventions like the one I described by the European Court yesterday, we have no international supervisory mechanism for this convention. Unlike every other major human rights treaty, there's no one who can call a breach. UNHCR is not interested in taking on that role because I think it makes its life difficult in terms of having the resources to hand out tents and blankets and things that are more politically palatable for the agency. We are at a stage where the law as written and as routinely embraced by states, including in the Global Compact, is in many, but I'm not willing to say most cases, but certainly in many, many, many cases not being respected. And by the countries that helped to draft the treaty, the UK, the United States among them. So it is a really difficult position now. And I think the only way that's going to change, at the risk of continuing to sing this song, is if we come up with a coordinated, managed global refugee protection system with real burden and responsibility sharing and real oversight at the international level. And quite frankly, I think states would be willing to buy into this once they actually understand how that would enable them to manage situations with greater efficacy, at lesser expense, and with less trauma. But that's not been a project that the UN Refugee Agency has been prepared to champion, tragically.
Thank you. I'd be very tempted to take you up on the debate of whether non-refoulement is a norm of customary international law, of which you are, of course, an eminent minority, but I think it's right to say you are probably in the minority among jurists and academics. But I think I'll avoid that temptation and take you to another question that was posed by one of our participants. And that is, it's still on the theme of pushbacks. In the Michigan guidelines on refugee freedom of movement, you and your fellow drafters envisage that situations of mass influx may, in extreme situations, justify a derogation from Refugee Convention obligations on the basis of necessity. But you make clear, of course, that those situations will be very rarely permitted indeed, given the narrow definition of mass influx and of necessity, and the very rare situations, if ever, that reform on would be the least intrusive or a proportionate response. And in this connection, you've criticized the decision of the Strasbourg Grand Chamber in ND and NT in Spain, and you called it bad law. Would you be able to elaborate your views on that judgment?
So there's a lot in that question. So there has always been an understanding right back from the beginning that there was a mass influx exception to the duty of non-refoulement. That was discussed by the drafters. It has been acknowledged by scholars in the UNHCR throughout the decades, but what has not happened is a careful framing of precisely what that would entail. And so what we tried to do in the Michigan guidelines to which you make reference, Laura, was to actually draw on other principles of international law to, if you will, circumscribe the notion in a way that aligns with general principles of international law. And the notion of necessity was the one that seemed to us to be right. There would be virtually no circumstance in which a state's most basic interests, which is the necessity test, would be irreparably damaged and for which there was no alternative answer other than the refoulement of refugees. But one could imagine, at least in principle, that if, and you know, there was a situation decades ago where Tanzania received 1.5 million refugees in 36 hours. I mean, you could imagine a situation like that being so drastic in such a difficult circumstance that it might be argued that necessity would enable some means short of entry to be applied and not breach Article 33. The NDNT judgment that you referred to, I mean, I think it may not be quite right to say that I've criticized the judgment as simply bad law. I've said that the judgment did a lot of things that were fabulous. It said that seeking asylum can be done in any manner, that it's a declaratory status. It was clear that territorial jurisdiction was all that was required to engage the duty of non-refoulement, that it includes non-admission at the border, for example. All of these things were correct and fabulous. There were two things, though, that were in the judgment that make me very nervous. One is the court suggested that refugees have a duty to take advantage of legal procedures for admission rather than entering unlawfully under their own steam. And I don't believe that's correct. Again, going back to Article 31, I think it is true that if effective lawful means that actually work well are in place, a refugee may have a hard time making the case against penalization under Article 31. But that does not allow you to refool the refugee back to the country of origin. The suggestion from the court that that might be a permissible answer where other mechanisms for entry were available is, I think, incorrect. The other suggestion that the court made, for those of you who are, who like me, can't continue to relive our tort law class, was a little bit like the violente non fit injuria principle that said, you know, you kind of made this mess yourselves. You rushed the border. You shouldn't have done this. And if you're the author of your own misfortune, you really can't complain. And I think that remark by the court was also legally unfounded and pragmatically and contextually naive, if I may. That's not the way things work in a situation like this, where a country has erected barbed wire barriers to ensure that people can't have access to the protection that in principle they're offering. So there is a lot of good in the NDNT case. What I'm suggesting, though, is that I think a necessity-based understanding of an exception to non-refoulement would be a lot safer as a matter both of law and principle than the take advantage of legal procedures and violente non fit injuria stuff that the court sort of threw out in that judgment, which I think could actually work real damage to refugees.
The exception that you envisage in paragraphs 12 and 13 of the Michigan guidelines for, for extreme situations of mass influx, that's not in the text of the Refugee Convention. It's right to say that it's an implied exception.
That's right. And I mean, during the drafting, the term non-refoulement came out of French law, as will not surprise you given the language in which it's expressed. And the French drafter made clear that there had always been in French law, in the duty of non-refoulement, an understanding that in context of an undefined, sadly, mass influx, it would not be applied. So states have, over the course of the last 70 years, invoked that understanding on multiple occasions. What I'm suggesting is, quite frankly, if you say it's watertight and that non-refoulement applies no matter what, even if your own citizenry's most basic survival is at stake and there's no other option, if you make it that extreme, you invite states to breach it. What we did instead was to say, we acknowledge that at some incredibly extreme level, it is conceptually possible that non-refoulement might not be respected, but that exception needs to be conceived in an extraordinarily narrow frame, in line with what public international law generally has seen to be the necessity principle. And by the way, that would include a duty to call on other states to receive those refugees rather than simply turning them away. So it's not simply you yell necessity and can put up the barricades. It's a notion with a great deal of jurisprudence behind it internationally that we can draw on, whereas, quote, mass influx, unquote, simply isn't. It's so fungible as to be really quite dangerous in my view. And again, Laura, to add the two passages from NDNT that I mentioned to you into the equation, I think it makes it even more dangerous because it does sort of say, oh, by the way, if there was another good option for you, refugee, and you didn't use it, well, maybe we actually can send you back, which is just not true.
Yeah. Yeah. Thank you.
So I guess if we make things so extreme for states that they feel that it begins to make us look ridiculous, I think we do refugees a disservice. And what we need to do is to lock states into the legal principles that they've drafted rather than letting them holus bolus make it up as they go along.
On that subject, coming now to a question of mine, which I would love to hear your answer to. Obviously, environmental degradation is increasingly going to cause mass movements of people who can point to no convention reason, but who are displaced purely because their home areas become uninhabitable. So setting aside people who may have a convention reason associated with climate change, what about those who can't point to one? Some people may say that that is a reason why the Refugee Convention requires some modification. And do you agree, or do you think that any notion of modernizing the Refugee Convention is unnecessary and dangerous?
Well, let's just start with the last adjective. It is most certainly dangerous. If you open the Refugee Convention for one reason, you open it for everything. You can't selectively say, let's renegotiate only on one point. I mean, we had this debate 30 years ago when many of us thought, as a matter of principle, it would be right to add sex or gender or sexual orientation in as a listed ground. Of course it would be right, but strategically it would have been idiotic, because had we done so, as opposed to using the social group mechanism to get us to yes, we would have opened that treaty in ways that I'm sure would not have ultimately proved to the benefit of refugees. The idea that they're simply going to add lots of good stuff and take away nothing, I just think it's incredibly naive. So in terms of the environmental degradation thing, I mean, you've made the point, and I won't, continue to make it, but an awful lot of people, and this was pointed out by the New Zealand courts, will be able to claim fleeing environmental degradation, will be able to claim classic convention refugee status. Because, and this is the key point, it isn't just because somebody wants to hurt you because you're Black or female or a Jew. It's sufficient if they fail to protect you for those reasons. And many countries where environmental degradation is occurring are privileging the protection needs of certain subcategories. Those who are unprivileged, if I can put it that way, in my view, have a valid convention refugee claim. But if we go to your basic idea that what if the whole country is sinking? What if everybody, Black, white, male, female, young, old, everybody is equally at risk? Then you're correct. None of them is a refugee. But my answer to that is, what do they really look like then? If the whole country is basically sinking, if the country is disappearing as an entity, this isn't about refugeehood. Refugeehood is about people who are persecuted for who they are or what they believe. It's much more akin to statelessness. Your country is gone, right? If we're going to be amending anything, we should be amending the Statelessness Convention, because that is really the parallel, it seems to me, if indeed an entire country ceases to function or to indeed to exist without any element of discrimination being involved, either in access to protection or the infliction of the harm. So I would be incredibly loath to open up the world's most powerful human rights treaty, the Refugee Convention, knowing that if we open it up to get rid of the nexus clause effectively, which is what the question you're posing suggests, if we were to do that, A, that we could possibly succeed, we're not going to succeed, but B, to imagine that if we were to open it up for that, we wouldn't lose probably Article 31, if not Article 33, rights to work, freedom of movement. We're going to lose a lot, if not all of that. And if we want to have a debate about an appropriate framing, as I think we should, then my suggestion is the framing should be about a new form of statelessness. Because when environmental degradation causes countries no longer to be viable, that's the better parallel, it seems to me, than is refugeehood.
Thanks so much. One last question we have time for. What do you predict 70 years from now? Will we still be celebrating the Refugee Convention in 2091?
Again, I love, will we be celebrating it? I don't know. I don't know if we'll be celebrating. I think we'll be in a comparable dilemma. I mean, 25 years ago, a group of 120 people came up with a model to fix the Refugee Convention's operational mechanism. We assumed that by now that would long since have been done. UNHCR sat on it and did nothing for 25 years, gave us a lot of pious language in the global compacts. So I think it's going to be another 25 years before we're even around to having a serious conversation about binding burden and responsibility sharing in a global protection regime. My guess is we're going to limp along as we do, and that the power of creative lawyering, the fact that we've been able to expand the nexus grounds, that we've been able to expand the understanding of being persecuted, that we've been able to contest the turnbacks to the extent that we have, at least at the European Court, in the Inter-American Court and elsewhere, I think that's going to be probably the way forward. It's not where I want to be. I wanted to be somewhere dramatically more celebratory, to choose, to go back to your language, but we've been stymied in that regard by a reform process that was really wrong-headed and which did not deliver on the commitments that we needed to revitalize the convention. That would have been the gift to the Refugee Convention at 70, to actually do the third pillar that the drafters always intended. The first was the definition, the second were the rights, the third was the operational mechanism. We could and should have done that in the global compacts. We didn't. And quite frankly, I'm not sure that I believe we have the willpower to do it now in ways that we didn't a couple of years ago.
James,
sorry to end on a gloomy note.
Thank you so much, nonetheless, for your time, for that incredibly thought-provoking discussion, replete with ideas, critiques, and a few grounds for optimism among the despondency. Thank you so much.
It's absolutely my pleasure. And I do want to thank all the lawyers listening, because you are what has kept this system functional to the extent that it is. And without lawyers at the coalface, all of the research that people like me do would be completely useless. So thank you so much for everything you do to make asylum at least viable for a significant number of people who desperately need it.
Thank you. Over to you, Antonia.
Thank you very much, Professor Hathaway. Laura, thank you so much for that fascinating discussion. We'll now move on to our panel discussion, and we're delighted to be joined by 3 expert panelists who will each speak for about 15 to 20 minutes. As I said at the outset, we're very keen to hear and answer as many questions as we can, and to be as interactive as possible in this virtual format. So please do post any questions that you have in the Q&A function, and we'll address as many as we can at the end. We're firstly going to hear from Dr. Daniel Gezelbash, who is an associate professor at the Law School of Macquarie University in Sydney, Australia. Dan's research focuses on Australian, international, and comparative refugee law, with a focus on the diffusion of restrictive asylum policies across jurisdictions. Dan has been a visiting fellow at the Refugee Studies Centre at Oxford University and a visiting scholar at the law schools of Harvard, Brooklyn, and New York. He's a practicing lawyer, special counsel at the National Justice Project, and founder and director of the Social Justice Clinic at Macquarie University. Dan has authored a book published in 2018 by Cambridge University Press entitled Refuge Lost: Asylum Law in an Interdependent World, which conducts an interdisciplinary analysis of the diffusion of harsh and restrictive border control policies across states, and which he'll draw upon in his presentation. We're particularly grateful to Dan for joining us in what are the early hours of the morning in Australia. Dan, thank you so much whenever you're ready.
Thank you so much for having me, Antonia. As Antonia mentioned, I'll be talking about some of the ideas from my book, Refuge Lost, looking at the tendency or the way restrictive policies are spreading around the world, the impact this is having on the ongoing viability of the international protection regime, and also directly speaking to the proposals to adopt elements of Australia's policies in the UK, and I guess drawing on the costs and damage that those policies have had in Australia, I guess, as a warning for the UK not to emulate Australia's approach. Now, next slide, please. So around the world, states have been turning their backs on the protections provided to refugees in the Refugee Convention and in the subsequent human rights treaties. We've entered what Thomas Gammeltoft Hansen and Nick Feith-Tan describe as a deterrence paradigm. So states
Dan, apologies, and I just interrupt you for a moment. We've lost your sound and can't hear you at the moment.
Sorry, am I back there?
Yeah, you are back. I think if you could maybe backtrack about 30 seconds to where we lost you. Apologies for that.
No worries. Apologies for that. I inadvertently leant on my mute button on my headset. Was talking about this, so the deterrence paradigm that we're in right now, where states are paying lip service to their obligations under international law, but going to great lengths to implement increasingly elaborate and punitive measures aimed at keeping asylum seekers away and making them unable to access those protections. We have border walls going up at higher rates than ever before, stopping land crossings. We've got the uses of interdiction and pushbacks at sea to stop asylum seekers seeking protection by sea. And of course, the sort of elaborate measures we have in place in terms of carrier sanctions and visa requirements that make it near impossible for most asylum seekers to be able to travel by air. I mean, this graphic that I've got up on the screen exemplifies the this mindset. This is a real ad campaign that the Australian government has run since 2013, and very unabashedly advertising to the world that it will deny protection to those people who try and reach its territory. And while the deterrence paradigm predates the COVID-19 pandemic, the onset of the pandemic has exacerbated some of the underlying tendencies towards restriction. And this has happened both with explicit public health or restrictions based on public health or justified in relation to public health grounds, but also more subtly with where states are using the pandemic as a cover to pursue agendas that they may not have been able to get away with in previous times or in non-pandemic times. Next slide, please. The decision of a state to adopt restrictive policies does not occur in a vacuum, but it's deeply interconnected with the policy settings of other states. States are increasingly acting in an environment where they see each other, see themselves as being in direct competition with one another to deter asylum seekers. And this has given rise to a race to the bottom as states try and outdo restrictive measures applied in other jurisdictions. It makes sense to monitor and emulate policies abroad across all policy areas, but there are some characteristics of asylum policy making that make it particularly susceptible to emulation and copying and diffusion. The first characteristic is interdependence. So the policy settings in one country have both direct and indirect impacts on other countries. And at a direct level, if if an asylum seeker is stopped at the border, they are pushed back into another jurisdiction. And at a more indirect level, there's this perception that stricter or more lax policies in one country can have flow-on effects for other countries. We also have in the asylum space, I guess, increasingly states viewing themselves as having this common policy problem, that is to try and keep asylum seekers away, but also operating under a shared constraint, which in the form of the Refugee Convention and the human rights treaties. And so when one country comes up with a solution that sort of addresses that policy problem without falling foul of those common policy constraints, or at least paying lip service to those external constraints, it can spread like wildfire throughout other states operating in that same paradigm. But it's not just the restrictive policies that are spreading. We also see the diffusion of the sort of bad faith legal justifications that states use to get away with them, as well as other measures for avoiding accountability, like secrecy, and also a spread in similar rhetoric used to both to justify them and sell them to the public. Next slide, please. And so it's in this context that we see increased interest in the so-called Australian model. At a very general, like at a high level, it's a suite of policies including mandatory long-term detention, offshore processing, boat pushbacks at sea, and temporary protection for certain asylum seekers. But it's beyond those specific policies. It's framed around this rhetoric that there is a right way and wrong way to seek asylum and access protection, and that on the wrong way being so that spontaneous asylum, that is a person deciding on their own volition to cross borders and seek protection, and disregarding the fact that that is the exact modality of movement that was envisioned and protected in the Refugee Convention, and instead favoring either resettlement or people coming through and arriving on other visas and subsequently applying for protection. The irony is that almost all of the so-called Australian model is directly based on US practice, and Australia very closely modeled its policies on US practice. So the US has operated offshore processing and interdiction regime in the Caribbean going back to the early 1990s. For my book, I interviewed some senior US policymakers who basically told me they were in the room when Australia was developing its first incarnation of the offshore processing and interdiction policy back in 2001, and provided very, very high level policy advice to Australia. The difference is that the US has generally gone about its policies quietly, while Australia, perhaps feeling a bit nervous about its position as a middle power, has gone to great lengths to try and promote its approach and a bit to justify what it's doing. And it's found a receptive audience in Europe. So that when there's been interest in elements of Australia's approach long before Australia adopted it, the Europe has been talking about. There's been offshore processing proposals in Europe as far back as sort of the 1980s, but I guess the Australian model and its perceived success has provided sort of renewed impetus for some actors to have a renewed push for the adoption of such policies. It started with sort of the parties of the far right. I mean, you'll see the graphic on screen of Geert Wilders from the Netherlands Party of Freedom, who's directly taken the Australia's infographic in one of his YouTube videos there. But we've seen the calls for the adoption of the Australian model, or at least elements of the Australian model, spread into sort of mainstream politics, and even parties that were sort of traditionally aligned with the sort of the left side of the political spectrum, such as the Social Democrats in Denmark, who have adopted an offshore processing proposal recently. And it's in this context that the UK Nationality and Border Bill is being considered. If you go to the next slide, please. So we see a lot of the core elements of that so-called Australian model appearing there. Increased reliance on detention, potential use of offshore processing and boat pushbacks, and temporary protection, and importantly that rhetoric and distinction between modality of arrival and the penalizing spontaneous arrival and spontaneous asylum. You'll see the tweet up on the screen from Priti Patel, who was hosting our Australia's former Prime Minister, Tony Abbott, who has, since leaving office as Prime Minister of Australia in 2015, seems to have been working behind the scenes, both publicly and behind the scenes, to kind of promote the Australian approach in the UK. But I'm assuming as part of those discussions, the devastating impact and costs of the policy were not raised. And if you could go to the next slide, please. So, I mean, there's I can't go into as much detail as perhaps I would like on this particular point, other than to say that Australia should not be a model to emulate, but a cautionary tale. There is a terrific policy brief out recently by my colleagues Madeline Gleeson and Natasha Yakub at the Caldor Centre that goes in a great deal of detail about sort of the costs of offshore processing in particular. But I guess at a high level, the first and foremost has been the devastating human cost of Australia's policies. Starting with pushbacks. Pushbacks can never be safe. There's been numerous incidents where there's been significant loss of life in the course of Australia's pushback operations, and there's also the incalculable cost or harm in terms of the number of people who have been returned to locations where they've faced persecution or potentially death. But that's not something we can quantify. Offshore processing is horrific by design. The conditions have to be worse than the conditions people are fleeing in order to encourage returns, and as well as prevent future arrivals. And it's not surprising that this leads to devastating human toll, both in terms of mental and physical health. Australia's offshore processing policy has resulted in at least 18 deaths, mostly due to either suicide or the inadequate medical care. There's also the issue that you have to send to make it work. You have to send absolutely everyone there. There can't be any exceptions, and that's why we saw the large number of children sent offshore as part of Australia's policies, and the result being not only documented endemic sexual assault and harm against children in the offshore processing setting, but also suicide attempts from children as young as 5. The temporary protection also has had a devastating impact on, particularly on the mental health of people subject to that. So Australia has the policy of people arriving by boat can only access 3 or 5 year visas, and they have to go through the process again. And like the proposal in the UK, they're unable to bring out their family. And so they've been out, we've had that policy in place for close to 8 or 9 years. And it has really taken a toll. There's again an epidemic of suicide within that cohort, and psychologists have to come up with this term, a sort of lethal hopelessness, to describe the situation in which they're in. I mean, the financial costs have been mind-boggling. Offshore processing has been costing on average half a billion pounds per year, and there's also been hundreds of millions of dollars paid out in damages and sort of tort claims brought on behalf of people, both on onshore and offshore detention. So I guess those are the harms that are most commonly talked about, but there's other important things to consider the sort of social costs. And I argue that Australia's harsh approach has really torn the fabric of Australia's sort of multicultural society, and it's not possible to vilify one portion or one of the migrant community without sort of flow-on effects to other migrants. And there's some have drawn a sort of direct link between the race rights we had in 2005 and the rhetoric and politics around refugee and asylum program that was sort of developing around that time. But I guess what's really the heart of my book, Refuge Lost, and again, perhaps one of the biggest costs that is often overlooked in discussions about this, sort of the domestic policy decisions, is sort of the flow-on effects that these decisions have for other jurisdictions. So, I mean, the first thing to note is that Australia's approach has had significant reputational costs, and it has, given the questionable nature under international law of Australia's policies, it has undermined Australia's moral authority to call out human rights abuses abroad. For example, Chinese representatives have cited Australia's treatment of asylum seekers to deflect criticism of their government raised by Australia in relation to various human rights violations occurring in China. More importantly, it's undermined our ability to engage in refugee protection issues in the Asia-Pacific region. And there's a great deal of sort of goodwill in sort of Asia-Pacific about developing new approaches to protection and sort of regularizing pathways to regularization within the region. Australia's been completely cut out from that discussion because we have taken sort of a unilateral approach of deflection and responsibility shifting, rather than working with our neighbours to develop sort of responsibility sharing arrangements. And onto my final slide, please. So, but the second point in terms of that the flow-on effects and the importance of being mindful that domestic policy changes have broader ramifications internationally, is that they contribute to basically the end of spontaneous asylum and the right to seek asylum. So we will see a domino effect as other states close their borders to asylum seekers. And if wealthy states of the global north are not providing access to protection to asylum seekers, how can we expect states with fewer resources to do so? And I'll just leave you with the quote from the final passage of my book, Refuge Loss, if I may. So the protections set out in the Refugee Convention and other human rights treaties are only words. Their effectiveness in the real world is shaped by state practice. The implementation of international law into state practice requires leadership. It needs states to set an example to convince other states to adhere to protection norms. This role has traditionally been carried out by wealthy liberal democracies, which have had the resources and ideological legitimacy required for the task. The restrictive policies introduced in the United States and Australia examined in this book mean that these nations now lack the credibility to take on this leadership role. All eyes are now on European states. We are at a tipping point. If Europe goes down the same path as the United States and Australia, it will be inflicting a mortal wound on the universal principle of asylum and on the international refugee protection regime more broadly. And on that very somber note, back to you, Antonia.
Dan, thank you so much for that very interesting and timely sharing of experiences in Australia. It's fascinating. We're now going to move to our second panelist, who is Jelia Sane, a barrister here at Doughty Street, who is a specialist in international law, immigration and asylum and children's rights. Jelia has broad experience in asylum claims and has been involved in landmark judicial review litigation concerning the family reunion rights of unaccompanied minors in the Calais jungle. She also has extensive international experience advising individuals, non-governmental and international organizations, and is currently instructed by the World Organization Against Torture as a lead legal analyst, investigating human rights abuses against people traveling in mixed movements in sub-Saharan Africa, including refoulement, sexual and gender-based violence, and torture and other ill treatment in connection to EU externalization policies. Jelia is also a member of the Legal Action Committee of the Global Legal Action Network, a strategic litigation NGO working on the protection of the human rights of migrants. Jelia has been based in Greece since 2018 and regularly contributes with NGOs seeking to document and challenge border violence at the Greek and Turkish borders. Jelia, whenever you're ready.
Thank you, Antonia, and hello, everyone. So I'm going to speak about how EU externalization policies are implemented in Africa, and specifically in Niger, and about some of the effects that these policies are having on access to international protection and the enjoyment of fundamental rights. Slides, please. Thank you. Now, you might be surprised to learn that today Europe's southernmost border is not in fact the island of Gavdos off the coast of Crete. That's at the bottom left of the screen, but in fact the city of Agadez in the center of Niger, a country located, as you can see on the map, thousands of miles away, but where the management of migration is heavily influenced and guided by the European Union and its member states. Now, the reason why I've chosen to focus on Niger for my presentation today is because whilst a lot of the attention in recent years has been on Libya and deaths at sea in the Mediterranean, Niger is also a major transit country for people traveling towards North Africa and Europe. In 2016, for instance, according to the International Organization for Migration, around 400,000 people traveled through the country, relying on a relatively formalized smuggling system. So consequently, Niger has become a key EU migration partner. In the last few years, it's received hundreds of millions of euros in EU funding to curb irregular migration, and has been described as the most advanced laboratory of externalization policies. Next slide, please. So firstly, what is externalization? Anyone that's been following the news over the last few years will be aware that the European Union, in response to irregular arrivals, has adopted a migration policy based on fortification and deterrence. Externalization is a key pillar of this policy, and it's a process by which the EU and individual member states outsource border control to countries of origin and countries of transit through a range of generally opaque and legally dubious cooperation agreements. The goal is to prevent irregular movement, and the consequence is that refugees and migrants are contained where they are long before they can ever reach European shores and be subject to the jurisdiction of member states and access international protection. Most of the EU's externalization partners in Africa, countries like Libya, Sudan, Chad, and Niger, have extremely poor human rights records and fragile or inexistent asylum systems. Yet the EU is enlisting these states to act as Europe's external border guards in order to stop refugees and migrants from crossing the two main physical obstacles on their way to Europe, namely the Mediterranean Sea and the Sahara Desert, without there being any proper human rights safeguards in place. Now, what's in it for these countries? How do you incentivize these countries to cooperate, particularly in circumstances where the very migration the EU is seeking to prevent can in fact be positive for a number of sub-Saharan African countries from a development perspective? The answer is initiatives like visa liberalization programs, but it's also money. So essentially, the EU provides funding and assistance in exchange for this cooperation. And in recent years, it's been hardening its approach in the sense that it's now making access to development aid conditional upon countries agreeing to cooperate with Europe to prevent irregular migration and to readmit irregular migrants. So if you're a country like Niger, which is the least developed country in the world, you can see how it might be impossible to say no to Europe. And just as a slight aside, I just want to flag that this approach has been denounced as constituting a form of border imperialism, especially because cooperating countries in Africa are very rarely involved in the formulation of the policies that are going to be implemented within their borders. And it's an approach that suggests that although European nations might have formally withdrawn their colonialist hold over Africa, there remains a deeply uneven power imbalance between Europe and these third countries, which sees European nations deploying a carrot and stick approach to respond to what is a political priority, but for Europeans, and to directly intervene on questions of border control and migration management, which are very much questions of national sovereignty. Now, externalization is not a new phenomenon. However, there has been, sorry, next slide. Thank you. So this is not a new trend, but there's been a massive growth in the externalization measures that the EU has adopted since 2015. And that's a year, you'll remember, in which over 1 million refugees and migrants crossed the Mediterranean into Italy and Greece, and around 4,000 perished at sea, which sparked a deep political crisis within the EU. Next slide, please. So a number of instruments were adopted as a response. These include the EU Emergency Trust Fund for Africa, which was adopted under the European Agenda for Migration following the Valletta Summit in Malta, and I've just put a picture there of the summit. So that was in 2015 between the EU and 35 African states. So the trust fund is the main funding mechanism for EU externalization, and the money comes from member states, from the European Development Fund, and from across the EU budget. It's currently valued at over 5 billion euros, and it funds programs, and as you can see from the map, in numerous countries across the Sahel, Lake Chad, Horn of Africa, and North Africa, including programs designed to tackle irregular migration. And as you can also see from the map, the recipients of the fund include Niger and Libya. Next slide, please. So shortly thereafter, in 2016, the EU adopted what it calls the new partnership framework. Now, this is a framework which relies on a lot of the measures that the EU has been adopting over the last decade or so. But what it does is that it really embeds irregular migration, and I quote, at the top of the EU's external relations priorities. So very much at the heart of the EU's foreign policy action is the objective of curbing irregular migration. And the framework sets out a range of measures designed to, and I quote, tackle migration upstream. Next slide, please. So how do you tackle migration upstream? Well, there's lots of things that you can do. Firstly, you can strengthen your external borders by reinforcing the capacity of coast and border guards in third countries to intercept and detain migrants. This is the model used in Libya. Next slide, please. Another prominent feature of the externalization project is militarization and securitization of the border. So that is building the capacity of security forces. It's going to be deploying military equipment, drones, and satellite surveillance to monitor migration routes. And in Niger, the EU has gone a step further insofar as migration and border control have now expressly been integrated into the EU Common Security and Defence Policy mission in that country, which traditionally has been about countering terrorism. Next slide, please. And now the other thing that you can do is that you can provide financial and technical assistance to countries in order to get them to adopt stricter border control measures. And this is what's happened in Niger. So in 2015, Niger adopted an anti-smuggling law under considerable EU pressure, such that it's often referred to as the Valletta Law by Nigerian public officials. In broad terms, this legislation criminalizes those who facilitate irregular entry or exit of third country nationals, and those convicted face up to 30 years in prison. One key problem under this legal framework is that there is not a clear distinction between perpetrators and victims of smuggling. So what's happening is that individuals who might be victims of smuggling or trafficking are being criminalized and detained for irregular entry. This undermines their right to seek asylum, and it's also at odds with the non-penalization clause under the Refugee Convention. The second consequence is that increased border controls by the Nigerian authorities under this law, who are being logistically and financially supported by the EU and also individual member states. So we know that Italy, France, and Spain, for instance, have actually deployed national police and military forces on the ground in Niger who are working side by side with local officials. So increased border controls have resulted in a de facto ban of all, I don't know if you can see Agadez, which is in the center of the country. So there's now a de facto ban of travel north of that city, which is miles away from the border. And this is a practice that has been confirmed by Frontex. In 2018, the UN Special Rapporteur on the Human Rights of Migrants visited Niger and found that these policies had contributed to a deterioration of the rights of refugees and migrants, including through refoulement, criminalization, and arbitrary detention. Notwithstanding all of these problems, the EU has hailed its cooperation with Niger as emblematic of what can be achieved with a transit country. So the reason for this is that there has been, it's true, a decrease in the number of people traveling along the main routes north of Agadez directly to the Libyan border. So there's a city that you hopefully can see on the map called Segedin, which is a midway point between Agadez and the border with Libya, where the number of people traveling north dropped from 290,000 in 2016 to 33,000 in 2017. But what these numbers don't tell you is that rather than actually reducing irregular migration, stricter border controls under this law are simply forcing people to take longer and more dangerous routes. And so those are the ones that are in lighter orange on this map. And so a multitude of informal desert routes have emerged that bypass the main hub of Agadez altogether and follow more closely the border with Algeria and the border with Chad before people finally make their way up to Libya. Next slide, please. Now, these new routes are more expensive and they're more dangerous, and abuses and deaths in the desert have significantly increased since the adoption of the law. According to the Global Migration Data Analysis Center, the number of migrant deaths in the desert increased from 71 in 2015 to 427 in 2017, 2 years after the adoption of the law. And I should say that this is likely to be a gross underestimate because there is generally very limited data on desert deaths and countless bodies are simply never found. So what is the justification? Well, externalization is often framed as a security imperative, which is an approach which presumes an inherent risk stemming from irregular migration, or it's presented as a life-saving humanitarian endeavor that's about reducing dangerous border crossing and combating smuggling and trafficking networks. Now, obviously, saving lives and tackling organized crimes are laudable and perfectly legitimate goals. However, the EU's current approach, which emphasizes deterrence, criminalization, control, and containment, is deeply problematic. Firstly, because it ignores the reality that safe and legal routes are largely absent. So people in search of safety often have no choice but to travel by irregular means and to rely on smugglers, because although international law recognizes that everyone has the right to leave any country, including their own, and the right to seek asylum, it doesn't establish a corresponding right to safe and legal pathways. Next slide, please. Additionally, the logic of externalization is fundamentally at odds with a protection and human rights approach. That is because the intensification of border control, if it's not accompanied by measures that are designed to address the drivers of irregular migration, and if it's not accompanied by the creation of safe and legal pathways, only traps people in a vicious cycle. So what we've been seeing playing out in Europe and elsewhere over the years is that there's an increase in the numbers of deaths at sea or at land borders. That leads politicians to calls to calls to fight smuggling, and then to adopt even more stringent border security measures. And these, in turn, increase the likelihood of people resorting to even more dangerous routes to avoid detection, and drives people straight into the hands of smugglers and traffickers. And we see this in Niger. There is a mounting body of evidence that externalization heightens the vulnerability to human rights abuses along the route, including torture, unlawful killing, sexual violence, forced labor, and slavery. These risks and the profound suffering and victimization caused by externalization are well documented, yet it seems that the EU and member states are willing to tolerate and accept this if it means protecting their borders. Additionally, externalization is not only punitive, but it's massively disproportionate as a response. That is because developing countries, not the EU, host most of the world's forcibly displaced. If you take Africa as an example, 80% of migration in West and Central Africa is internal to the region. and only a small minority of people try to reach Europe, and most are eventually granted international protection. Finally, externalization undermines access to international protection. If you prevent asylum seekers from exercising their right to leave any country and to seek and enjoy asylum, and if you detain them for doing so, that basically is a pullback policy. If you transfer asylum seekers and refugees to other countries without sufficient safeguards, if you detain people in extraterritorial processing centres, you're undermining people's ability to access protection, to access legal remedies, and exposing them to incredibly harmful and dangerous detention policies. And with all of these measures, ultimately what we're seeing is an erosion of the international protection system. And rather than facilitating access to international protection through international cooperation, as called for under the Convention and the Global Compact on refugees, we are obstructing it. And this is a deeply concerning state of affairs, because at the end of 2020, the number of people forcibly displaced had reached 82.4 million globally, which is the highest number ever on record, including 20 million refugees. So this is not an issue that's going to go away anytime soon, yet there doesn't seem to be any impetus to change the approach. On the contrary, one of the new proposals in the EU's Pact on Migration and Asylum is to introduce a pre-screening of third country nationals at the external borders of the EU. So it's even more externalization. So it seems to me that on the anniversary of the convention, we need a new and better international system, one that is anchored in human rights, that protects and upholds the rights of people where they are, rather than punishing them for how they got there. Thank you very much. That concludes my remarks.
Jelius, thank you so much. That was fascinating. We're going to move now to our final panelist, who is Anthony Vaughan, also a member of Doughty Street Chambers and a specialist in public law and human rights, with a particular focus on immigration, national security, deprivation of liberty and human trafficking. Tony regularly works in complex claims in both the domestic and international courts. He's been involved in landmark challenges to the UK asylum system, including on fast-track asylum processing, in relation to victims of trafficking, medical examinations for asylum seekers in detention, and exclusion from international protection on criminality grounds. He's also a contributing author to MacDonald's Immigration Law and Practice, including on immigration detention. Thank you, Tony.
Thanks very much, Antonia. Thanks to Professor Hathaway, Dr. Gazelbash and Jelia for your presentations. I want to start with a bit of history. Between August and October 1914, around 80,000 Belgian refugees arrived on the shores of Kent. The county of England, for those who don't know, is closest to the European mainland. So those refugees were fleeing German occupation, and most of them arrived in Folkestone Harbour. And the population of Folkestone had only then been about 16,000 people. But those refugees were welcomed, accommodated and protected. They arrived with no visas, and their treatment here prompted the King of Belgium to say this: Folkestone has earned the admiration not only of the Belgians, but also of the whole world. Yes, the whole civilized world knew how the town of Folkestone had received them with such cordiality, which would never be forgotten. Fast forward 107 years, and the UK's south coast is a very different picture. It sees inflatable boats overloaded with desperate people seeking sanctuary, border force pushback training exercises, locking up asylum seekers in dilapidated army barracks. There's a race to the bottom on immigration rhetoric and political points scored on the backs of desperate people. So we're celebrating the Refugee Convention's 70th anniversary in a context whereby the protection of the Convention is undergoing gradual erosion by successive UK governments of all stripes. The most recent iteration of this is the UK government's Nationality and Borders Bill, which has had now its second reading in the Commons before the summer, and it's currently at committee stage. There's obviously a lot to comment on in relation to this bill, but in my part of the seminar, I'm going to touch on two main features of the bill and look at how they sit with the Refugee Convention. And the first is this new concept of the inadmissible asylum claim, and relatedly the possibility of offshore processing of asylum claims. And the second is this proposed two-tier or even three-tier system of refugee protection. Next slide, please. So in relation to inadmissibility, the immigration rules and the policy basis for this are already in force. My colleagues, Alistair Mackenzie and Camilla Zapata-Besso, did a great seminar on those immigration rules and policy documents earlier this year. But what this bill does is put those provisions on a statutory footing. I'm just going to take you through the key elements of it and then comment on what the Refugee Convention, how the Refugee Convention sits with those. So the provisions are key in clause 14 and 15 of the bill. So this gives the power to declare an asylum claim inadmissible where the person has a connection with a safe third state. And there I've given you what the person's liberty and life are not threatened in that state by reason of race, religion, nationality, etc. 2, the state is one from which the person will not be sent to another state, either in breach of the Refugee Convention or Article 3. And the person may apply to be recognised as a refugee, and if so recognised, receive protection in accordance with the Refugee Convention in that state. Next slide, please. So I've set out here what connection means. And that according to this bill. So that would be a state, I won't read them all out, but they include a state where the claimant has been recognised as a refugee and remains able to access protection, otherwise granted protection, which precludes return to another state in breach of the convention, place where they claimed asylum, they were previously present in and eligible to claim asylum to a safe third state, and it would have been unreasonable to expect them to make such a claim and they failed to do so. So it would have been reasonable to expect them to claim and they failed to do so. And it would, in the claimant's circumstances, have been reasonable to expect them to have claimed asylum in a safe third state instead of the UK. Next slide, please. So we have the next slide, please, Ray? That's it. So what are the consequences of an asylum claim being declared inadmissible? So they are removal to the particular safe third state through which the individual passed, any other safe third state, and this is really the shocking part of these proposals, even if they've never set foot there. And it could include other places, and I'll come back to this, including offshore processing centres. But the Secretary of State, even where a case has been deemed inadmissible, the Secretary of State can still decide the claim in the UK, where, for example, the removal is not possible within a reasonable period, exceptional circumstances. Next slide, please. So what are the consequences? Sorry, next, one more slide across, please. So So the first issue I want to look at is that of the prohibition on non-refoulement. Article 33 of the Convention says, no contracting state shall expel or return refouler a refugee in any manner whatsoever to the frontiers of territories where his life or freedom will be threatened on account of his race, religion, nationality, membership of a particular social group or political opinion. Now that applies to all refugees unless they present a danger to the community under Article 33. And it would apply to those whose asylum claims have not as yet been recognised. And so as Professor Hathaway said, refugee status is a declaratory status. And this extends to onward refoulement, meaning expulsion or return to a territory where the person does not face a real risk of harm, but from where there is a real risk that they will be expelled on to their country of origin or to somewhere else where such a risk exists. And its effect is that the third state must be able to provide the individual with effective protection, including effective judicial remedies. And the UNHCR, I think in its response to the proposals, the policy paper, has made it clear that the application of the safe third country principle requires an individual assessment of whether the country will grant the person access to a fair and efficient procedure for determining refugee status. So bearing in mind those principles, there is nothing in this bill or in the accompanying inadmissibility guidance that requires the Home Office caseworker to decide anything about whether the country of return would provide safe and effective protection. It doesn't require them to look at remedies. It doesn't, in particular, require them to decide these matters to any particular standard of proof. Is it real risk? Is it balance of probabilities? There are very real risks that the UK will return refugees under this scheme to countries which won't properly consider their claim or prevent their onward return to persecution. Reception conditions. There are rights under the Refugee Convention which have to be secured to people, including during the period before their claim has been recognised. And I've referred there to non-discrimination in access to rights on the basis of other aliens in a similar position. It's unclear what inquiry will be made about these matters. And at the moment, it seems on the basis of the proposals that really there are no proper safeguards at all in these areas. Next slide, please. One of the most fundamental problems with the inadmissibility regime is the fact that it penalises asylum seekers who went illegally and didn't claim asylum en route to the UK. And I'll come on to why having your asylum claim declared inadmissible is to be regarded as a penalty. But a really important point that Professor Hathaway made relates to what it meant by coming directly. So what he says in his book is this, and it is really important because he referred to the approach of the signatory states when the Refugee Convention was being drawn up. He says this in his book. Importantly then, the only intended retrenchment from the general goal of exempting refugees from penalties was with regard to those who had found asylum, that is, those who had chosen to give up a secure, even if not permanent home, not those who had failed to seek asylum. Indeed, and this is interesting in the current context, indeed, the British representative successfully argued that the reference to being unable to find asylum even temporarily should be eliminated, since it might be taken to mean that a refugee would have to establish not merely his refugee status, but also that he was unable to find asylum in any other country other than the one in which he had applied to settle. Thus, the onus of proving a negative would be placed on the refugee himself. Oddly, that is now exactly what the UK's proposals now seek to do. And the key point here is coming directly was intended to refer to an asylum claimant who hadn't found secure protection following their flight. UK courts have recognised that the Refugee Convention affords individuals some element of choice as to where they claim asylum. And that was a case called Queen and Uxbridge Magistrates Court ex parte Ademi. And this is also the UNHCR's interpretation. So how coming directly will be interpreted in terms of this statute remains to be seen, but the bill opens up the very real risk that the mere failure to claim asylum en route to the UK will render the claim inadmissible. And certainly treating the claims of asylum seekers who entered the UK unlawfully as inadmissible, delaying their claims, would arguably constitute a penalty for the purposes of Article 31. Next slide, please. And we'll skip over, just given the time. What was said there is that the other elements, without delay and showing good cause, are good cause for illegal entry, are fact sensitive. Next slide, please. So I'll just comment very briefly on this because the Borders Bill isn't expressly about offshore processing, but it does contain the legal architecture for transferring responsibility for asylum claims to other territories or states. Now, what it does, the thing though that does show that they are trying to lay the architecture is the amendments to what are currently sections 77 and 78 of the Nationality, Immigration and Asylum Act 2002, which is a really important safeguard that asylum lawyers frequently rely on, which prevents, it's an absolute rule, it prevents the removal of any asylum seeker pending the determination of their claim or appeal. But what this bill does in Schedule 3 is to amend those provisions so that you can remove a person with a pending claim. Now, under this regime, the only reason you do so, or one of the reasons you do so, is to transfer them to somewhere else where asylum claims are being processed. So this offshore processing idea would encompass people who have admissible claims for asylum, which the Home Office have accepted responsibility for. But I think for present purposes, I'd say that the details are still unclear, but do raise obvious concerns about where those people would be required to remain. Would they be detained? Would they have access to legal advice? Those who are used to going down to Yarl's Wood or Harmondsworth IRC know how difficult it is to take instructions in detained asylum cases. And what this regime would present is difficult to comprehend. If we could go to the next slide, please. Yeah, but I've just pointed out here that the new plan for immigration paper does anticipate that but the key point is that they haven't been able to convince any country to conclude an agreement to process the UK's asylum applications. And without that actually occurring, this proposal won't go anywhere. But it does mean that you will get many more people put into the temporary protection regime, which I'll come to in a moment. Next slide, please. So this is the temporary protection regime. I've called it two-tier, but it may even be three-tier. And this is a UK version of what Daniel was describing and really reflects Priti Patel's idea of what a deserving refugee looks like. So that is, and they're called Group 1 refugees, that is people who came to the UK directly from a country where their life or freedom was threatened, presented themselves without delay, and if they are entered or are present in the UK unlawfully, they can show good cause. Now, I'll pause there to just explain what I mean by the three-tier policy. The policy paper actually states that refugees recognised elsewhere and resettled to the UK will receive ILR on arrival. They will be inevitably Group 1 refugees, but there's an obvious prioritisation in this scheme of resettled refugees in preference to those who have arrived here lawfully or not. And then in that second category is subdivided into the good refugees and the bad refugees, which seem to be covered in clause 10. If we go to the next slide, please. So the Group 2 refugees are those who haven't satisfied those three criteria. Next slide, please. And we can see that the powers in this bill are intended to be given to allow the Secretary of State to treat Group 1 and Group 2 refugees and their family members entirely differently. And the bottom line is the policy proposal is to give temporary protection to Group 2 refugees, which are grants of leave of no longer than 30 months leave to remain, after which they're then reassessed for return to their country of origin. With no automatic right to settle. And this is in a context whereby at the moment, recognised refugees are given 5 years leave to remain and then settlement. Next slide, please. So penalties. I think it flows from what I was saying earlier, that this is quite obviously a penalty in terms of how you are treated because of the way non-penalisation of those arriving irregularly is a key principle of the Refugee Convention, and it's quite clear that a differential approach in this way is inconsistent with it. It's particularly difficult to see a justification for that in circumstances where there are no safe or legal routes to claim here. The second point is to flag is the fact that there's an obligation to facilitate naturalization in Article 34 of the Convention. Very difficult to see how preventing somebody from ever getting settlement or making it more difficult to achieve it is in any way compatible with that principle. Next slide, please. And what about how you remove this protection? That the idea in this policy paper is essentially to make people go back to where they came from at the expiry of the 30 months, unless there's a good reason not to. And the policy paper makes it sound as if this is just going to be a fresh reassessment of risk. But anyone who's done asylum cases as a practitioner or studied this area knows that you can't just take away refugee status like that. You have to satisfy the cessation and exclusion provisions have to be satisfied. And in relation to changes of country conditions, for example, the burden is on the Secretary of State to show that there has been fundamental changes in circumstances. And there is nothing in this regime which shows that the Secretary of State is going to apply those tests or a test which is as difficult to satisfy as those provisions. It would be difficult to see how they could not, but there is nothing in the policy paper or the bill to suggest that those cessation and exclusion rules are the test. I'm conscious of the time, so I will draw it to a close there, but those are really some of the key issues. But as I say, there are so many to cover and it does make for depressing reading, but I'll call it a day there. We can go to questions.
Totally, thank you so much. Before we start some questions from the floor, we've obviously heard a range of information coming both domestically and internationally, and I wondered if any of the panelists had any comments that they wanted to make on anything that's been said by any of the other speakers, or any food for thought that draws upon what's gone before. No, I'll take that as a no. Thank you. Firstly, the first question I think directed to Gelia is what routes, if any, are there to challenge externalization in the EU?
Thank you for that very easy question, Antonia. I mean, one of the problems is that externalization agreements tend to be quite opaque, and that fixing the EU with responsibility for what happens outside of its borders or the EU's partners can be challenging and requires innovative legal thinking and strategies. Now, that's not to say that the situation is completely hopeless, and there's nothing that we can do. And in the last couple of years, there have been a number of creative challenges, and I'll just refer to three of them. So the Global Legal Action Network has been quite active in this area. And currently is seeking to challenge, for instance, the use of EU funding, the trust fund funding that I mentioned, to finance migration management programs in Libya. That's because part of that money comes from EU development money. And so the argument is that you can't use funds that are destined for development programs to finance border security projects that have got nothing to do with development. So we'll see that's a complaint that's being brought before the very glamorous European Court of Auditors. So we'll see what happens with that. There's also been an interesting challenge before the Working Group on Enforced Disappearance, basically making the argument that a lot of the pushback practices that we're seeing in northern Greece, so on the land border, a place called Evros between Turkey and Greece, and we also see this in the Aegean, where basically people arrived in Greece are stripped of all their belongings and then basically pushed back, never to be seen again. But there's an argument that that could constitute a form of enforced disappearance by the Greek state. So that's an argument that currently is being advanced before the Working Group on Enforced Disappearance. Finally, the International Criminal Court, which has been investigating Libya for almost a decade now, but really looking at the conflict, has more recently broadened the scope of its examination to look at crimes against migrants in Libya, to assess whether or not part of the treatment and conditions inflicted upon migrants potentially constitute crimes against humanity. So things like murder, enslavement, imprisonment, torture, and sexual violence. So that would be individual criminal responsibility of Libyan officials. So those are three ways in which externalization is currently being challenged with extremely limited success, I have to say, thus far.
Thank you. Dan, if I may, a question for you, looking also at legal challenges. You mentioned when you spoke about damages claims for individuals in Australia, but can you give us a sense of any more systemic challenges and whether those have been brought in the Australian courts to the policies you've described?
So unfortunately, the only success we have had has been using tort claims, and that is because of the fact that we don't have a Human Rights Act or any sort of really other rights mechanisms to enforce, and also because there's been this bipartisan support for these policies for so long. There have been really innovative, interesting strategic litigation approaches that have been developed and that would have been successful based on the law at the time. But every time that occurs, the government has passed retrospective legislation, so plugging that gap. And one of those approaches was sort of similar to the sort of following the money that Jelia mentioned now, which was just basically challenging the authorization of government spending on offshore processing. But yeah, so the only successes we have had have been through tort law. It has cost the government, a huge amount of money. I mean, it has put some pressure on them, but obviously for now they seem to be willing to pay the costs in order to continue the policies.
Thank you so much. And while I have you, can I ask another question that's coming from the floor about temporary entry visas that you spoke about? As I understand it, for those who've categorized as spontaneous arrivals before they're allowed to apply for refugee status. That's obviously something we're concerned about in the drafting of the bill. And I wondered if you had a sense of the grant or refusal rates and how that's played out in Australia.
So is that with regards to the renewals or?
Yes.
So the thing with our temporary protection regime has been that it has been incredibly slow. And so it took about 3 or 4 years before anyone was allowed to apply for a visa in the first place. And we are only now just coming up to the first round of renewals. And it's too early to tell whether there will be significant numbers that would be returned. I mean, a significant part of that cohort are from Afghanistan. I would be very surprised if the Australian government is going to start returning people to Afghanistan. But I think that this just underscores the sort of the additional problem with that program, which is the immense burden it puts on an already stretched asylum determination system. And so we already had these huge delays, but then having to go through and reassess the claims without making a really substantial investment in processing capacity, which we haven't done, has just meant that people just spend years and years and years just in limbo waiting. Even just for temporary status, they have to wait for years and years.
Thank you very much. Another question that's come through for Tony this time is about the bill and the interplay with Section 31 statutory defence under the 1999 Act, of course, appears to be fundamentally inconsistent. And the question is, do you see that as a source of future confusion?
Yeah, absolutely. I mean, the case of Ademi that I referred to, Simon Brown LJ's judgment is really useful in giving a number of different factors that are relevant to the effect of not claiming asylum en route, such as how long the person stayed in the country of transit, whether they obtained de jure versus de facto protection, a number of different factors, which are which is a helpful case to try to explain the scope of the Section 31 defence. But it's clear that the policy angle, the policy direction that underpins this bill is that they want to take a much tougher line on that. And although they always say that the proposals are in line with our international obligations, there's always an attempt to push the boundaries of those obligations to make them as narrow as they can. And there will inevitably be a fight about that particular issue and many other issues where the courts have already interpreted provisions like Section 31 and other statutory concepts against one particular policy and political background versus the much more stringent and authoritarian background and context that we now have. So that's a good question, an example of one area where we're going to see fights, but it is one example of many areas that we're going to see challenges.
Thank you very much. And the final question that's come through is a general one, but I think important, taking away everything, all of the food for thought that we've had this afternoon, is how do we connect the legal profession with campaigners on the kinds of issues that we've been discussing? Of course, both are valuable, but often there is a disconnect. Really open that to all three of you, if anyone wants to start on that point.
Well, one option is that you leave London and move to Greece and work there. I mean, I think that is a really important question. And I think often as lawyers, there's a risk, especially at the bar, I think, compared to how lawyers practice in other countries, but that we operate a little bit in silos and we're not very connected to the organizations who do this work. So I do think that it's important for us to also try and familiarize ourselves with the reality on the ground, to have, I think, fora like this where it's possible for lawyers, academics, NGOs to exchange ideas and be in these discussion spaces. And I think what I found really useful, so even this project that I've been doing with MCT now for a couple of years, where we're looking at abuses along these routes, it's really, connecting with the NGOs that have access to the underlying facts and evidence, and then working collaboratively to design sort of advocacy, policy, and legal strategies. So I do think there's a space for lawyers to do this work, but I would say that we have to be proactive in terms of engaging NGOs who might not always, know that it's possible to use these sort of creative legal strategies. So yeah, us being proactive, basically.
I would also say that you just shouldn't hesitate to ring up lawyers that you think might be able to help you, because the bottom line is that knowledge is not mine or anyone else's. It's everybody's, and there can be a thing about the bar that this profession constructs, that you're sort of sitting there in your ivory tower and no one can speak to you. I mean, it's certainly in these chambers, there's a lot of barristers who worked on making submissions, briefings on this bill, and we're always happy to collaborate and to give input to help. But I completely agree with everything that Julia just said too.
Thank you so much, Dan. Any comments you wanted to conclude with? I
guess maybe just slightly tangential to that point, but I think given that policymakers and politicians are talking and learning from one another in implementing these restrictive practices, I think as sort of campaigners and lawyers, it's really important to have these sort of cross-jurisdictional discussions and learn from each other's experiences as well. And in that regard, I was delighted to be invited to participate today.
Absolutely, thank you so much. And exactly on time, just to conclude by saying a huge thank you to all of our three panelists, Dan, Jelia, Tony. It's been fascinating, very grateful for you joining us. Thank you to everyone who's joined us from the floor. It's been a really varied mix of people attending internationally and in the UK. And we're very grateful, of course, to Professor Hathaway and to Laura Dubinsky for their opening. So thank you very much all. As I mentioned at the outset, the recording of today's event will be available on our website shortly if you want to share it with colleagues or have it for future reference. Thank you very much.